All rise. Court of Appeals Division 1 is now in session.
Please be seated. Good morning, everyone. We are here for oral argument in cause number 1 CACV 180249, Okland versus Zurn. These proceedings are being audio and video recorded, so we ask counsel, please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve any portion of that time for rebuttal if you so desire. We've read the briefs. We've discussed this case in our morning conference. And counsel, you may proceed.
May it please the court, I'm Matthew Splitak of Quarles and Brady. It's my privilege today to give argument on behalf of Zurn Industries, LLC, and Zurn Pex, Incorporated. The Superior Court's judgment must be reversed and all claims against Zurn dismissed for three principal reasons. Number one, the statute that the court relied upon, 12-684, expressly conditioned indemnity upon a judgment being rendered against Okland, and none ever was.
Is that 12684?
12684, that's correct.
Raise that below?
There is a waiver issue, which we acknowledged in our briefs, concerning our arguments about the text of 12684. And as we argued there, the court should reach the 12684 issue on the merits. And the reason is because the answer is so clear. The text of 12684 states that indemnity requires that a judgment be rendered against here, Okland.
Let's pause right there.
Yeah.
If that statute is so clear, why wasn't it raised below? And now we have a ruling from the Superior Court. You never gave the Superior Court the opportunity to address the facts of this case under that statute, and here we are on appeal. Doesn't that act as a disservice to the litigants and the Superior Court? Why should we step in now?
I agree that the question whether a judgment had been rendered against Okland was not argued.
Okland actually stated specifically the only thing we are standing on is it's precluded by the class action. Over and over and over again, Zurn said that in defense to Okland's claim. So if that's the only thing they raised below, shouldn't they be limited to that being the only thing we address on appeal?
No, because this court has the duty to apply the statute correctly.
No one asked that we apply the statute below, so this is the part that I'm having difficulty getting over. If the court had been presented with that problem, if your client had raised that in the trial court, we would have a different issue, and we'll all agree to that. But at this point in time, your client didn't. So why is the statutory defense that that Zurn is trying to assert not precluded?
Well, I wouldn't characterize it as a defense. I think it goes to the elements of Okland's claim.
Okay.
There are cases, including, as we cite in our brief, a number of them, City of Tempe, where the appellant had not responded to a summary judgment motion. The Brown decision as well, where controlling precedent was not cited by either party below. In this court on appeal, I think the right result here is to apply the plain text of the statute correctly. And in order to resolve the issue, this isn't a case where there's any factual dispute. All that needs to be done is to look at the text of the statute that was before the Superior Court and a single document in the record, which is the stipulated order of dismissal that Okland argues constitutes a judgment rendered against it.
And that's all downhill argument. Right now I'm asking you. The Superior Court didn't misapply the law. Agreed?
I do think that 12684 was misapplied.
It wasn't applied. Nobody asked it to be applied. Would we agree?
Well, Okland asked the Superior Court to grant indemnity based on 12684, and that's the only authority the Superior Court relied upon.
And your client didn't oppose that. They defended solely on the class action litigation. So if none of the challenges to the application of 12684A occurred below, why do you get to challenge it here?
And again, because the statute should be applied correctly according to its plain text. It wasn't below. I agree that the arguments that we have raised about the text of 12684 were not argued below. But the answer is clear. It's a pure issue of law, and this court should not allow an incorrect application of 12684 to stand.
And when we look at the issue of waiver happens in a lot of different circumstances, but when we look at the application of the waiver doctrine, doesn't that say you've waived the opportunity to challenge that issue because you didn't challenge it below? Regardless, do you see what I'm asking you at all?
I do. I do.
Answer that directly.
I agree that the waiver rule, which is a rule of judicial administration, can apply here because the arguments that we're making about the text of 12684 were not raised below. And our response to that is this court, in any event, particularly in cases where it's applying statutes, its overriding goal is to make sure that the statute is applied correctly, notwithstanding that arguments were not raised below.
So is it this court should or this court may not find waiver?
I read the American Family and Yolen cases, which we cite, to say that this court has a duty to apply the statute correctly. I certainly also think it may not recognize a waiver here. Clearly, it has the discretion to do so. I want to turn to the class action settlement agreement, where there is no waiver issue. That was, as you pointed out, Your Honor, argued to the Superior Court below. As a preliminary matter, the settlement agreement applies. It applied to the plaintiff homeowner's claims. The Superior Court was in error when it ruled that the settlement somehow did not apply to claims that arose after April 1, 2013. The federal court order and the agreement itself, they're explicit that the settlement applies to claims both before and after that date. The plaintiffs below were members of the settlement class, and the federal court in Minnesota and the parties to the class action, they anticipated the very situation that was presented below. And what they decided in the settlement agreement, which is part of the federal court's order, it was incorporated into that order, is that class members, such as the plaintiffs, are free to sue third parties like Okland here and to recover damages caused by those third parties. But they are not able, because of the settlement agreement, to compel a party like Okland to pay for any damages that are attributable to defects in Zurn's plumbing fittings. And the effect of that is Okland never could have owed an actual liability to the plaintiffs that it would have needed indemnity for from Zurn. If Okland could prove that damages were attributable to defects in Zurn's plumbing fittings, then the plaintiffs could not compel Okland to pay for those damages. If they'd recovered a judgment against Okland, the settlement agreement and the court order would require that judgment to be reduced to whatever extent was necessary.
So the settlement agreement applies only to product defect claims, right?
It applied to claims, however they're denominated. It wouldn't have to be a claim styled a product defect claim, but any claim relating to Zurn's plumbing fittings.
So when Zurn received the tender of defense from Okland, did Zurn take any steps to explain that to Okland, to push that point, to participate and make sure that Okland and the court knew that before this mediation took place, this mediation that Zurn was invited to attend and did not?
Before the third-party complaint was filed, even, in February of 2015, and this is cited in our brief, Zurn's counsel did write to Okland's counsel, and this was my colleague's predecessor counsel, to be clear, to explain the settlement agreement and to specifically highlight the provision in the settlement agreement that would prevent the plaintiffs from recovering from Okland any damages that were attributable to Zurn's plumbing fittings.
And pointing to a settlement agreement is not equal to assisting Okland to defend against this claim that your client says is precluded, but you lost in the trial court on that point. So it's not as clear cut as that, is it?
Zurn did not accept the tender of defense. You're correct. There is a difference between that and accepting the tender of defense. And as we argued in our brief, in addition to there never being a judgment rendered against Okland, Okland also did not meet the threshold requirements for invoking 12-684 in the first place. I don't think Zurn was obligated to accept the defense that was tendered by Okland.
Seems a little cyclical to me, and it may just be me. So Okland gets sued, or Okland. Do we pronounce it Okland or Okland?
I've always said Okland.
Okay, we'll keep with Okland. That one's easy. So Okland gets sued. They tender the defense. Your client refuses to provide any assistance in their litigation. Okland settles the matter, and then your client allows Okland to go through all of this and then says, no, you can't collect from us. We don't have any duty to defend. Did you not kind of sit on your thumbs and let them make a mistake legally, if that's in fact what you see happened?
Well, I think that Okland and its insurers who actually made the settlement payment went into the settlement with their eyes open, having been informed very clearly, even before the third-party complaint was filed, that this settlement agreement applied and that the plaintiffs were not going to be able to hold Okland liable for any damages that should be rightly attributed to Zurn instead.
Isn't that speaking, and correct me if I misunderstand the record or the claim, but isn't that speaking a little broadly? I read the settlement agreement to protect you from claims of product defect, bring out other claims. Is that correct?
The settlement agreement released Zurn from any claims in any way relating to the plumbing fittings. I don't.
not simply to defects in the plumbing fixtures, the plumbing equipment?
I do think it's broader than that in the text of the releases. And it certainly covered the plaintiff's claims here, and I assume that's why the plaintiffs didn't sue Zurn. The settlement agreement left the plaintiffs unable to recover from anyone, from Zurn or from Okland, any damages that were attributable to Zurn's plumbing fittings.
So the settlement agreement with Zurn and the class action plaintiffs barred third parties from suing?
Well, the settlement agreement, it limited what the plaintiffs could recover from a third party like Okland. And the federal court's order said explicitly that Zurn will not be liable for any contribution or indemnity claims brought by a third party like Okland.
Any claim for anything?
Well, relating to the fittings that were at issue.
Okay.
But regardless of how the claim is styled, it wouldn't matter if the claim is styled as a product liability claim or a negligence claim or a breach of warranty claim, what have you.
Okay.
And the effect of this is that Okland never could have owed an actual liability that Zurn could have indemnified. And this is something we cited in our opening brief, the Hurston decision by this court. And in that case, the Hurston court looked at a settlement agreement that similarly allowed plaintiffs to pursue non-settling defendants, but only for damages caused by those non-settling defendants, only damages that those non-settling defendants were severally liable for. And the Hurston court ruled that because that's how the settlement agreement worked, the non-settling defendants would never have any basis to claim indemnity from the defendants who had settled out. And that goes right to the elements of a common law indemnity claim, which would require an actual obligation owed in common by both Zurn and Okland. Whereas here, because of the effect of the federal court's order and the agreement it incorporated, neither Zurn nor Okland could have owed the plaintiffs anything relating to the plumbing fittings. Compensation relating to those claims is already being paid in the $20 million class action settlement. I have a couple minutes left that I'd like to reserve, but if the court has any other questions, I'd answer those as well, of course.
All right, counsel, we'll reserve your time.
Thank you.
We'll hear from Okland now.
Good morning. I'm Denise Wackles with Renault Cook Drury Maceros, here on behalf of the Appley Okland Construction Company.
Counsel, can you focus on the scope of the settlement agreement and what claims are barred and what aren't barred?
Yes, Your Honor. I would be glad to. So, first, as we did in our briefing, we would direct the court to the final order that adopted the settlement agreement in the Zurn class action litigation. And that order at page 20, paragraphs 13 and 14, and that is opening brief appendix item 77. It says, the settlement agreement does not bar a party from filing, commencing, prosecuting, maintaining, etc., lawsuits against any non-Zurn defendant, and I'm paraphrasing, including but not limited to builders and contractors related in the subject matter of the settlement agreement. Then paragraph 14, most significantly, the settlement class members' claims, that would be the homeowners that sued my client, Okland Construction, their claims against parties other than the Zurn defendants, including but not limited to developers, builders, etc., plumbers, installers, and other manufacturers of PEX plumbing systems, shall not be released by the settlement agreement. So I'm either the attorney representing a client who was too stupid to be able to read these documents and advise the client not to pay $2.8 million to take care of Zurn's faulty and defective plumbing components, or I appropriately read these documents as this final order and the settlement agreement in no way precluded the homeowners from suing Okland for its judicially implied warranties. And we, I cited in our briefing the Lofts case, that's the Arizona Supreme Court case, also followed by Division 2 of this court in Yanni, Y-A-N-N-I, both cited in our briefs. And it refers to a builder's warranty and implied warranty, not just for the entire home. And this judicially implied warranty is specific to homes, like the condos that Okland built in this case. It may or may not apply to commercial projects, but it definitely applies to homes. This is, the judiciary has implied this and specifically says the warranty is not just kind of liable for the home, they're liable for every component in the home.
So what does the settlement agreement cover? What does it preclude?
Well, specifically, as I think that the part of that settlement agreement that this court would want to look at specifically can be found in paragraph 95 of the settlement agreement. That's at page 28, and it's opening brief appendix 107. So it applies to the Zurn components, and we are I think all agree that the defective Zurn components that the settlement agreement applied to and that the class action applied to are in the condo project that my client built. But what it did was it gave Zurn rights against the homeowners. And it is a large document, but it is a document that anticipates that there may be claims just like the claims for indemnity, just like Okland brought.
Wait a minute. You kind of lost me a
I'm
little bit.
sorry.
If the homeowners don't have a claim against Zurn, then why would your client have a claim against Zurn?
Well, first of all, it is not the situation that the homeowners don't have a claim against Zurn. They do. This whole this class action settlement created obligations by Zurn to the class members that included the homeowners. They had rights that they could have pursued against Zurn to either recover remediation expenses or to have asked Zurn to remediate their
And
homes.
did they ever make such claims?
No, because it was they sued Okland instead of Zurn. But this is not just some massive release that operates only to benefit Zurn. It also operated to the benefit of homeowners like the 93 owners that sued Okland. So they had two recourses. They could sue Okland, which was nice and clean, or they could have sought recourse under the settlement program that this massive order and settlement agreement initiated. So they had rights, and what is significant here for the purpose of Zurn, of our indemnity claims against Zurn, is that we released or discharged Zurn's obligations to the homeowners that Zurn had under the settlement agreement. They had remediation, repair, and cash payment payment requirements under the settlement agreement that the homeowners could have triggered, but
Why would
elected
your
not
client
to.
do that in a settlement agreement? Let out a third party who clearly is at least partially responsible. So you enter into a settlement agreement, you pay the money, they've already refused to participate. So I understand it's a benefit to them, but not one that was given any consideration for. They said, go do what you got to do.
Oh, okay, well, you know what, we have two settlement agreements that are at issue in this case. We did not let Zurn off the hook. In fact, our settlement agreement with the homeowners specifically says, and that is, it's in the record on appeal, it's item 103, and it is Exhibit D to our statement of facts in support of our motion for summary judgment. It is the settlement agreement and release between Okland and the 93 homeowners. And in this agreement, this settlement agreement, we say over and over again, the above releases are not intended and shall not be construed to release Okland's third-party claims for indemnity from the Zurn third-party defendants. Also,
It doesn't release the indemnity claim. They've got this settlement agreement that's a class action settlement agreement between the homeowners and Zurn, which is what your opponents are arguing. You've got are representing Okland, who's being sued, and you enter into the settlement agreement, which lets Zurn off the hook. Their argument is they were already off the hook in relation to the homeowners. So,
yeah, but that's because they've kind of misrepresented the situation to you.
tell me how.
Because the settlement agreement between the settlement class members and Zurn has two sides to it. One is Zurn gets released, but it also has to provide consideration to the class members. And there is a provision in the settlement agreement. There is a heading that says consideration. And the consideration is they implemented a big repair program. They funded a $20 million program for remediation of properties that had the defective plumbing components in it. Well, because of Okland's payment to these 93 homeowners, Zurn will not have to pay any money to them, won't have to address remediation claims from these homeowners because we took care of it. And in the settlement agreement between Okland and the Safari Drive homeowners, paragraph 6 at page 4 even makes reference to the fact that $2.8 million of the payment constitutes full settlement of all claims against Okland, which relates or arise from the plaintiff's allegations related to yellow brass fittings and other system components alleged to be defective that were supplied to the project by Zurn and Zurn's distributor. So if the 93 Safari Drive homeowners tried to participate in the settlement class action remediation program or to obtain monies or funds from that program, Zurn would just flash this and say those claims have already been satisfied. So there is a, and that answers something that was raised in the reply.
Can we go on? Because I really don't want you to run out of time.
Thank you, I appreciate that.
Okay.
So
Let's talk about 12-681 and the definition of seller. And the argument that Zurn has raised is that your client does not fall into the definition of seller. You've made counter arguments to that claim made by Zurn, but I'm struggling with this. If we pull out the original complaint filed by Safari Drive and the answer that Okland filed after, prior to amending, but after in response, and we turn to paragraph 4 of the answer filed by your client, We have to go back to the complaint and match it up, and then we find out specific allegations. The original homeowners in this lawsuit said, upon information and belief, each defendant was a real estate owner, builder, developer, seller, and/or general contractor of the project for sale to the general public, and developed the project by constructing structures, improvements thereon, and it goes on. Then we have your client who filed their verified answer, and it says, in answering paragraph 7, which includes the word seller, it says, defendant admits the allegation that it served as a general contractor of the project. Defendant denies the remaining allegations, which includes that it's a seller. And then we get to the statute, and the statute is specifically premised on the fact that the products liability plaintiff needs to be a seller, manufacturer, etc. So can you address that?
Yes. And that is a bit, thorny, and I'm not here with any case. We do not have an Arizona decision that I'm aware of that decides the question that you are asking, is Okland a seller? But we can look at the reality. How did the...
There are cases that define seller and narrow it, but when your client specifically in a pleading filed with the court says it is not a seller, denies the allegation in the complaint that it's a seller, how do you then get to argue later that you are a seller?
Well, I think we, and the point that you've raised here is not one that I studied specifically for this hearing, but I would say we may have admitted that we did not sell the condos. So we worked under contract with the developer, and then the developer was the entity that actually sold the units. And I suspect the reason for that is this. There was, in the construction defect area of the law and the practice, before the Lofts case was decided by the Arizona Supreme Court, there was a defense that builders would take that they were not liable under the implied warranties if they were not also the vendor of the home itself. Lofts decided that issue against the builders and said, if you built it, you've made the warranty. But I think that it used to be significant, and this is a case that dates back a number of years, so I'm thinking that may have been a position that would have been typical to take on behalf of a builder, to say, I didn't sell the unit. But the statute is requiring something else. Did we sell? Are we a seller of the Zurn plumbing components for purposes of the statute? And that's why I say, let's look at reality. How did those plumbing components get into the homes? And as we discussed in our answering brief, Okland had a plumbing subcontractor, IMCOR. IMCOR installed the systems. IMCOR purchased the plumbing components either directly from Zurn or from a distributor. I do ask that you take a look specifically at our appendix, page 1, which was not part of the record due to the way things developed, but it will show you that Zurn was active in this project. They sent representatives out. They gave us a letter of insurance.
I'm still waiting for you to say where you were a seller of that. I mean, you used it, but you didn't sell it. Zurn, you didn't sell it. You're not a seller of that product.
You're a builder. You're a constructor.
We indirectly sold it because we paid for those Zurn components. We were paid by the developer, and then we paid IMCOR, and IMCOR paid Zurn for the components.
Well, you're a consumer of it then, because you bought it.
We did not, but we didn't utilize the system. The owners utilized the system so that they could have faucets in their bathrooms and toilets and all of that sort of thing. So I would not describe Okland as a consumer. And in fact,
So you're representing that that a builder is a seller of every component that goes into the building of a home.
Your Honor, yes, and because I think that the law in this area needs to be consistent with the judicially developed implied warranties by builders. If the builders are having to impliedly warrant all of the parts and pieces in the house, which lofts, and which, in a quote adopted and stated by the Court of Appeals in Yanni, we are the warrantor of all of those systems. So, if we can't be both a consumer of the systems and giving warranties to the ultimate consumers, the homeowners that purchase them.
So, steel company that, I'm just having a hard time getting my head around the idea that a builder which buys stuff to build, or home to build anything, is a seller of all the component parts.
Well, that is the way the Supreme Court and this court have viewed it, at least for purposes of requiring builders to. This is a judicially adopted doctrine of implied warranty. It's implied by the courts with respect to builders like Okland of homes, and so and the question that you're asking.
Does it meet the statutory definition or lack of definition of a seller?
I would argue yes, but given that I have 2 minutes left, I would, if I may, I would like to pivot because I recognize that the statute is problematic, and the statute was only one of two grounds for our motion for summary judgment. We also moved on the basis of common law or implied indemnity. That doesn't involve a statute. As explained and developed in our brief, we have the full ability under the law of implied indemnity to recover both the attorney's fees award and the $2.8 million that we spent satisfying that claim. And I would like to point, given that my time is so short, one of the cases that we cited in our answering brief is In Re Consolidated Vista Hills, a New Mexico Supreme Court case that involves the New Mexico Supreme Court looking at the question directly before you. A builder is claiming implied indemnity from a supplier of defective pressed wood used for a retaining wall on a large, I think it was 180 homes in that case. And the wood had been, there was a manufacturer, so to speak, the company that treated and created the wood, sold it to a lumber company, who then sold it to the builder. So you do not have the direct privity, just like you don't have here. And the New Mexico Supreme Court said that this was a paradigm for implied indemnity. We do not have an Arizona case that looks at a builder case like the one before this court, but we do have some very similar cases applying implied indemnity. And I would just again want to reiterate that the discharged liability is the Zurn. We achieved for Zurn a discharge of its liability under the class action settlement with respect to these 93 owners that forms the basis for our implied indemnity claim. This court can sidestep the thorniness of the application of the statute by looking at common law implied indemnity. In parting, I will just say Occam's razor. Sometimes the simplest way of getting to an objective is the right one. Thank you.
All right. Thank you, counsel. Any last words?
Very briefly, my colleague agrees that the class action settlement applied to the plaintiffs below. Okland did not discharge Zurn's obligations under the class action settlement agreement. The plaintiffs went outside the claims process for the class action settlement. They apparently made a strategic decision to do that, but once they're outside the claims process, Zurn doesn't owe them. And Okland didn't. It is not as if Okland responded to a claim within the claims process and paid out under the class action settlement agreement. That's not at all what happened, and Okland had zero obligation to do such a thing. By agreeing that the class action settlement applied, the effect is Okland never had any actual obligation to compensate the plaintiffs for alleged damages attributable to Zurn's plumbing fittings.
You would agree that you, at this point, have raised yet a new argument, which is your common law indemnity argument that you only addressed on appeal, not in the trial court.
I'm not willing to go that far. The class action settlement agreement was argued to the Superior Court, and the class action settlement agreement, its effect is that neither Zurn nor Okland owed an actual obligation to the plaintiffs to pay, to make the payment that Okland's insurers made. And that defeats the common law indemnity claim.
And that's because the plaintiffs didn't go through the claim process.
That is correct.
But that wasn't decided.
Below. The Superior Court did not rule on common law indemnity.
And you didn't argue against common law indemnity specifically. You just stood solely, and when I say you, I know it wasn't you, but on the class action argument, correct?
Applying to any indemnity claim, that's correct. One last point. Given that there's been a concession that the class action settlement agreement applied, paragraph 95 prohibited the class members, like the plaintiffs, from entering into a settlement with Okland without getting a release for Zurn as well. They were required to make sure that it all got wrapped up in that one settlement. That was violated, and Okland apparently was aware that the plaintiffs were in fact subject to that settlement, and I'm out of time.
All right, thank you, counsel. We thank both of you for your arguments here. The matter will be deemed submitted and taken under advisement. A decision will issue in due course. We are going to remain in session while we wait for the next litigants to come forward. Thank you very much.